right, well, hello, classes. As I say, I'm going to be uploading this video to all of the courses here through Canvas, as we will not be having class this week. But I told you all I care so very much about you all that I don't want to test you on things that I have not taught you in class or via Zoom. And I know that your exam this week is coming up on chapters 1 through 3, your midterm. And I wanted to go through some very pertinent things from chapter 3 that will help you on your exam. I do know that at any point that I could have just said, the normal 1 through 5 for this point, but I wanted to make sure you all were comfortable with where we were. And we've been moving slower due to COVID. So, here I'll be going through chapter 3 and giving you some nuggets and things that you should know to make sure you understand. And of course, again, we meet not this upcoming week, but the week after. If you have any questions, we'll address those. And if not, we'll move on to chapters 4 and 5 to try and catch up. But chapter 3 is very, very important. But another housekeeping thing is I said that this upcoming week you have from Monday, October 4th through Thursday, the 7th, to take your exam. I even allowed for you all to have 2 attempts. Yes, I love you all. I told you I'll put you in the best situation. I can bring you to the water, can't make you drink, but this is your opportunity to do well on there. Use your book, use your notes that I've uploaded, go back, and I'm going to put the other Zoom that we did together. I'm going to try and upload that again this evening onto Canvas so you all can review and take the test certainly when you're ready for it. But chapter 3 is on searches and seizures. And I want to tell you all that this chapter, when we talk about searches and seizures, we're talking about the Fourth Amendment. What the Fourth Amendment does is it bans only unreasonable searches and seizures made by law enforcement that they induce on citizens and things of that nature in order to balance, we are talking about the skill here, the government's power to control crime and the liberty and the privacy rights of individuals. So on this side, we have the government, their duty to empower to control crime throughout. And that's why we're talking about the criminal procedure process. And on this side, we have the citizens. And we have liberty and rights. And we talk about that liberty, that freedom being autonomy. Use those words when you're giving me those assignments. And there, we're talking about under the Fourth Amendment. It's so important. This is so heavy because it bans unreasonable searches and seizures. Y'all really want y'all to understand that. I'm going to leave this up for a week and I'm going to take it down. But I'm doing that for purposes of not being able to have class. And I want you to fully understand. If the government actions don't invade a citizen's expectation of privacy that society is prepared to recognize, it's not a search. So we're only looking to see if these law enforcement agents that's acting under the government, to see if it's actually a search or a seizure. First, we have to see that these actions have to invade an expectation of privacy. What do I, as a citizen, have an expectation of privacy to? Right? Obviously, myself. Things like my home, and there's other things that we're going to talk about. Maybe even my bag here, my purse, my belongings, a book bag. There are certain things I have an expectation of privacy to, and some things you don't. But it's not going to be a search, or even your phone. It's not a search. Unless you have an expectation of privacy to that thing or the extension of yourself. All right. There are 3 questions that you really need to know. We delve into this under the Fourth Amendment. It's a 3-step process here. The first question is when you're trying to see if a search has occurred or a seizure has occurred, the first question you ask is, was the law enforcement action a search or seizure? Whatever we're talking about, was it actually a search or seizure? Number 2, if the action was a search or seizure, was it reasonable? So this whole test is about the reasonableness of what these law enforcement officers did, this so-called search that you have. If you say, yes, this was a search, this was a seizure, okay, was it reasonable? All right. The third question is, let's say if it's unreasonable, the Fourth Amendment protects you if it's unreasonable. But if it is reasonable, no protection, That's just the government balancing that that crime right there. All right. So 3 is if the search or seizure was unreasonable, does the Fourth Amendment ban the use of evidence? I've been talking to you all about when you the evidence that an officer or a law enforcement agency may find on someone, when it can be banned. Sometimes you can use that motion to suppress that evidence, even if there's evidence found. But if whatever was done was unreasonable, excessive, things of that nature, then under the Fourth Amendment, there are times that you can ban that evidence. Remember that have and have nots example I gave you all in class. Okay, real quickly, I'm going to move on because I don't want to be on here too long. Crime control in a constitutional democracy depends on information. And it comes from the information that the police officers see and that they hear. So that's where they get the information from, because you use what you call ordinary senses, your senses to see, to hear, things that's going on. All right. Know that. Now, there are other sources that they think they can get it from. So if a police officer comes up and they are viewing a crime, obviously they depend on that for information. They hear it themselves. They depend on that for information. But there are other sources for which they can get information. Number one, criminals. The criminal, him or herself, who did this act and broke this crime, right? Violated this crime. That's one way to get information. That's one source. Second source, suspects. So a suspect is a person who has not been deemed a criminal. They have not been convicted, maybe not even have charges brought against them, but they may be a person of interest in figuring out what happened. That's a suspect. Then the third is a victim. The victim is the person of which this alleged crime or action was brought against. I gave you an example we talked about in class. I made very fun examples about the stalking incidents, and the person that was bringing the crime was the victim. The person, if someone steals from you and you're bringing that crime, you're the victim, right? So you can get a source. You are a source in the nature for which the police can get information. And fourth is witnesses. Those individuals who also saw and heard what happened in an event, okay? Let's see. All law enforcement officers must sometimes rely on involuntary methods to get information. This triggers the criminal procedure protections under the Bill of Rights, right? So you have some searches and seizures, and we have some called special needs searches. There's so many different types of searches and seizures that go beyond the purpose of crime control. But the reason why we have this is, number one, to protect officers from armed suspects. So on the officer side of it, we have here where they're trying to, they have a duty to protect and serve. When they're in that particular place, they have to be they have to look out for themselves. So when you come, officer comes upon somebody, they may be armed. So we want to see, these methods are put in place to search and seize to protect the officers, right, from armed suspects that they may or know or not know of. That's why they ask you to put your hands where I can see them. And they do a light frisk or search, right, to prevent drunk driving. That's important. That's why you want to search and seize, for the open containers and things of that nature. To protect the property of detained suspects from loss or damage. So you may be detained for committing some type of crime. Let's say they have you outside the car, handcuffed, away on the pavement, and they need to search your vehicle because you may have things or belongings in there that could possibly get taken or stolen in the process. We don't think about these things, right? All right, to protect officials from lawsuits. All right, to detect drug use among students and public employees. That's why we have you go into court, and sometimes even to some schools they have law detector screenings, right? When you travel, they have these things, right? And it's all for the duty to protect the whole in crime and to protect individuals from things like this. So that's why you have searches and seizures and things of that nature, to do that. Now, that's the government's duty. And then, you have that. And you may say, well, that's invading my rights, my privacy, my liberty, my autonomy. But the thing is, if it's to protect the whole, most of the time what the government does will prevail. It's only when we look at that test of reasonability that we determine whether what the action was too much. So that's why you say, was this a search? If yes, Was it unreasonable? Was it reasonable? And if the answer is still yes, then you go to the third thing. Okay, if it's unreasonable, is this a situation where we can ban this evidence? And a lot of times you can, right? So that's the way of the citizen balancing out what the law enforcement can do. I told you I'm giving you nuggets for your life to show you your rights, right? What's important to you, what you should know in certain incidents, especially when we have these ridiculous things going around, such as police brutality and other things going on. You have to know your rights so you can balance it out, okay? Just because you have a badge as an law enforcement officer and you're doing certain things, you have to make sure your actions are reasonable. Yes, you need to be protected in the process. So you do need to do the searches and seizures, but is it reasonable? Is it reasonable, right? Next. And I'm going to throw out some terms that you may want to be familiar with. I'm going to post them on your notes. So I'm not going to go through a lot of it. Liberty, privacy, the trespass doctrine. I may not get to all of this here, but I just want you to be familiar with these terms. Subjective privacy, objective privacy, reasonable expectation of privacy, right? What's reasonable? Should you have an expectation of privacy to your car, to your home, to your bag, right? To yourself? These are questions, all right? And there's several other, and I want you to go through those on your own time, looking through that. And we're also going to discuss here the Fourth Amendment balances the government's power to control crime and the right of people to be left alone by banning unreasonable searches and seizures. So if you're going to do that as a law enforcement agent, you're going to step outside of your duty and leave people alone. Do your duty. Make sure what you're doing is reasonable. Because criminal procedure and evidence, this class is all about those checks and balances, that scale. I do this all the time in class. It's a scale, right? It applies only to government actions, not to the actions of private individuals. So we're not talking about what the individuals do to determine if these actions are reasonable and unreasonable. This is about what the government does, like at these traffic stops and things of that nature, right? So if there is a reasonable suspicion or probable cause where an officer can search this vehicle and, apprehend a person or stop them or search them or frisk them, you have to make sure that their behavior was reasonable, right? It may not be reasonable to yank them out of the car and throw them on the ground and stomp the lights out of them and then say, hey, I found some marijuana or some alcohol in here, right? And you can argue as an individual that, okay, yes, an officer has a duty to do certain things, but when you search me in my vehicle, it has to be reasonable. So as long as I am not resisting and following the protocol that you are giving me, you have a right to search me, right? To seize certain things from me. But you can't be unreasonable, as an example that I did in inflicting excessive force or things of that nature. You can't do that, because then I can go to step 3. If it's unreasonable, and I can say, can this evidence that you found, this container, this marijuana, whatever else is gun, weapon, be banned in court? Can I suppress that? Because you're saying you're going to throw these charges on me, but can I ban that? That's why we're checking law enforcement, the government in itself, because law enforcement, FBI, whoever else, any agent that you have falls under here. And we have the individuals, right? The citizens, the private citizens over here. It's a check and balances that we have. All right. The third party doctrine holds that the Fourth Amendment does not prohibit obtaining information by a third party. So you have this false friend or undercover agent or these informants that tell on you, right? Let's say you told them that you killed a person or you stole someone's money out of their bag. And if they come back and inform law enforcement, you cannot then invoke this right to say, nope, you cannot take what I told my best friend or what I told this family member or what they saw or heard, and you cannot use that because I have an expectation of privacy to them. Doesn't work like that. Under the third party doctrine, it says that false friend undercover agents are not prohibited by the Fourth Amendment. You cannot then say I have an expectation of privacy to them. Check this out. Social media queens and kings, Facebook, Instagram, Snapchat, your text messages, and your phone, right? The court has ruled that the use of technologies such as these things, right, you may not have an expectation of privacy there. Once I make that status on Facebook, that is out there. You cannot then invoke that expectation of privacy to then say, this is my Facebook account. Nope. And that's private. I don't have it where it's public, this and that. It doesn't matter. You have posted that on the World Wide Web. You've made that submission. You've sent a text to your friend. Yes, this is your phone. You may have an expectation of privacy to an officer saying, here, give me your phone. Let me search it, right? You may need probable cause for that, to just you to just take my phone and search what's the contents of my phone. I have an expectation of privacy there. But to that text message that I sent out, that picture I sent out, that went to someone else. There's no expectation of privacy. You cannot invoke that Fourth Amendment to that. That's important, because I try to, tell you all to protecting your rights when you talk about this is a technology age, when you're posting everything and you're putting everything out there. Not just for that, but you have jobs and things that are coming out. You don't have an expectation of privacy that they go and they delve into that all the time. All right. Now, certain things like, in your workplaces, providing internet services, like emails when you're at work, you may not have an expectation of privacy there. All right. Obviously, there are some things that a warrant and probable cause is needed for, right? But you do not have, you do have expectation of privacy to what you have in your text and things like that. But once you send that to someone else, that becomes their text. So they can send that. So you may send something out to someone else, and if they want to turn that in, they can, because you've sent it to them. But to your messages and what's in your phone and your photos, yes, you have expectation of privacy there. So it's really what you transmit at that point. All right. A seizure of property is some meaningful interference with an individual's possession of property. So there's a meaningful interference that we're having here with my possession of my property and what I have, right? So we're also looking into the expectation of privacy there. Let's talk about trash. You have a home. I always ask, do you think you have expectation of privacy of the trash that's in your home? Even though I don't want it, I throw it in my trash, I put it in my washroom, and I close the door. Yes, expectation of privacy, because an officer or anyone else cannot just come in and just in my house and search my things and take it and seize it and say this is evidence of whatever sort. No expectation of privacy. That you do have expectation of privacy there in your home. If I put that same trash on my front porch, do I have an expectation of privacy? Yes. It is on my personal property, in my yard, in my gate, anywhere I have it. But once I pull that trash out to that curb, right? We're talking about the curtilage of the outside, the curb for collection, meaning where the city can come and collect that trash. No expectation of privacy. So if you put evidence in there or whatever sort that you have in there, you're saying you don't want it. So if a police officer or whomever wants to come and open up, search each person's trash outside of their home, they can. And you can't say, get out of my trash. It's on the curb of your home. You have no expectation of privacy there. Now, they can't come in through your house and open the fence and say, I'm searching this because it's trash, you've thrown it out. And you can say, I've thrown it out, but I have not put it on the curb. It's still on my property. No expectation of privacy. But understand is when it hit that curb, you put it out there where the state normally comes and pick up those things. No expectation of privacy. All right. Now, the Fourth Amendment does not apply to discoveries of evidence in plain view. So if you're on your porch and you're fussing and fighting with someone else and y'all getting a knockdown, and I want to say that it's disturbing the peace, and the officer wants to come and arrest you for that, and you want to say, no, I'm on my porch, this is my property, but you're disturbing the peace, making this grand outburst and doing these things, and y'all are fighting, yes, you have lost the expectation of privacy. You don't have an expectation of privacy there because it's evidence in plain view that these officers have viewed. Or if you're doing this in a public place, the mall, carrying on, doing these things and acting out and fighting and whatever else, you having these outbursts there, and there's a disturbing the peace charge there. You don't have expectation of privacy on public places. So you can protect certain things and say, this is my right. You're violating my Fourth Amendment right. Certain instances. That's why we're talking about that. Expectation of privacy. You have a right to a reasonable expectation of privacy, but certain places. Not in plain view. Not in public places. not in open fields, not on abandoned property. No expectation of privacy. So know these rights, know these things. All right, let's talk about this. I'm gonna give you this case. Electronic surveillance. There's no reasonable expectation of privacy in statements that include the following elements, right? Statements that are made by private individuals, okay? No expectation of privacy there, right? 2, statements made to and recorded by undercover government agents. Undercover people, you're being recorded by them. You can't say, well, I told them that in privacy, right? I have an expectation of privacy. I didn't tell them. It's out there. It's an undercover government agent, right? Or to private individuals. I told this person who I think thought was my best friend, and they told on me. That's my sister. That's my brother. I have an expectation of privacy. We're blood. Nope. They're a private individual. Once you do it to them, they can go and report it. You have no expectation of privacy. So basically, you can't control anybody else or anything else. These are my words. You can control yourself. So know your rights. 3, individuals who made the statements don't know they revealed to them, right? So you don't know that somebody's recording you or whatever else is going on, or that these special agents were recording that. This doesn't matter. That's electronic surveillance. All right. So under the third party doctrine, you have an assumption of the risk. I mean, you are assuming the risk. Once you tell these false friends or family members or whatever else, and y'all know when you start talking about people offering money as a reward, people are going to talk, right? And it doesn't matter what your relationship to them is. That's what it is. So false friends, companies who provide services, internet, social networks, no expectation of privacy. Once you post it and you say that, you assume the risk because somebody can screenshot it at any time. It's out there. You've put it out there and it can be gotten at that time. Even if you delete it, somebody could have already gotten it. All right. Essential services are like banks, telephone companies, things of that nature, trash, commercial, all that. Third party doctrine is about all that. It's about you assuming those risks to the third parties. Almost done here, giving you these nuggets. I want you to look at the Terry v. Ohio case, and I'm not going to go too deep into it, but I want you to read that on your own term. We're talking about searching and seizing, because that's going to be one of the cases that you have an opportunity, and I'm going to give you the next 2 weeks so you can prepare for your lawyer for the day debates day, where you were looking at searches and seizures. Until 1967, the Supreme Court defined searches according to the trespass doctrine. So it meant that officers had to invade a physically constitutionally protected area. All right, these areas included a person. I talked about a person. That's me, right? Myself. I have an expectation of privacy to myself. Okay. All right, 2, house, my house. That's why you have to have warrants, right? And probable cause to search homes. Now, there are some ways, and we'll talk about it later on in other chapters, where you can get around not having a warrant, like special needs searches. We'll talk about that later. But generally, to your person, your home, your papers, right? My items that I own, my money, my checkbook, what's in my phone, my cards here, right? And my effects, my purse, my book bag, right? What's in my car, right? Constitutionally protected area, meaning that is my right. So if you're going to search that and you have probable cause or reasonable suspicion to get you to that point, that's fine if you're going to search that, but it better be reasonable, because if it's unreasonable, then I have a cause to say whatever you find, you may not be able to use. They call that fruits of the poisonous tree. You got the fruits. You found something on me. You got something on me. But it's from a poisonous tree. The way you did it was wrong. It was poisonous. So the government may or may not be able to use that through suppression methods and things of that nature. All right. So I gave you those 3 questions that you need to have. That's very important to know. Now, the Fourth Amendment does ban all unreasonable searches and seizures. So that's your question when you're looking at cases and you're briefing them. You're asking yourself, was this reasonable? Okay. Now, However, it wasn't aimed to cripple law enforcement's power to say, hey, officer, you don't have any power. I'm a citizen. I'm going to get you on everything. That's not the purpose for it, okay? The purpose was to limit policing power enough so that these police officers and agencies can stop infringing upon private citizens' rights by doing things illegal that are unreasonable. That's why we have the Fourth Amendment, for checks and balances. You give one group or one entity or one agency too much power, we got issues. That's why we have that's why you think the president of the United States does not have all powers, because it's checks and balances. Therefore we have judicial branch with courts, and the legislative branch with senators and representatives who make laws. Everybody's checking behind someone else. Even though you might have the executive power to do this, I might have the power to veto it, or whatever we need to do. It's checks and balances. But it's so that these agents and the government will not infringe unreasonably upon two things: your liberty as a citizen and your privacy. Because you have a right to privacy. You have a right to your liberty, right? Those are the two things hold dear to: your liberty and your privacy. And the government cannot infringe upon your rights. That's why we have the Fourth Amendment. Okay? Those are the key things that I want to talk about here. I want to talk to you a little bit about the CATS test, and I'm going to wrap it up. All right. Under CATS via U.S., it's a case in Chapter 3. You may want to read it. Read Terry v. Ohio. It'll give you some perspective on what I'm teaching you about. CATS in CATS versus United States, it replaced the trespass doctrine with the reasonable expectation of privacy doctrine. So initially they called this whole thing trespass doctrine, like they're trespassing upon you. We don't use that anymore. We say reasonable expectation of privacy, right? The places are still important, right? But there are two tests. Subjective privacy, saying, did the person exhibit an actual personal expectation of privacy? Did this person do that? 2, objective privacy. Is society as a whole prepared to recognize this privacy as reasonable? And 3, the officer must be in a place that he or she has a legal right to. We talked about this in the Chauvin case when you had the officers that burst into the house. Individual had some contraband on his name. They had some paraphernalia, and they took these pills really quick to get rid of it before the officer came. The officer saw them, and they tried to take the drugs that they had that the man had already swallowed. The first question was, did the officers have a legal right to be there? Did they have a warrant to say they can get in the house? Was it any emergency situation to say that they can have probable cause to enter this home? They didn't in that case. So the officer has to have a legal right to be in that place. That's the first thing. And also in the Chauvin case, once the guy hurried up and took the pill real quick to say, I want to get rid of these drugs for the came, and the officers saw him, they began to beat on the man and do everything, trying to make him throw up the pills. We talked about that. That's absurd. But they did all that. So that was unreasonable. So yes, you had a search and a seizure of trying to get this contraband from this man, and you're beating him up in the process. That's unreasonable. Then they took him to the hospital, and they told the hospital workers there and the doctors and the nurses to pump his stomach to get those drugs out of his stomach. Absurd. So was this reasonable? That case talked about, the rule in that case was the Fourth Amendment. The issue was that reasonable what these officers did? Not so much about what Chauvin did. Was that reasonable? Because he took that to court. And originally, the trial court may find in that case that, hey, he was guilty of taking those 2 pills regardless. Oh, case closed. Nope, that's not why. That's why you have this class that tells you your rights. Yes, I may have been guilty of that, but I'm looking at the agents, the law enforcement, the government's actions there. They were not reasonable. You don't have to beat this person, make them throw up and pump their stomach to get those pills out. So because that was unreasonable, the Supreme Court overturned that decision and said that was unreasonable. Chauvin, this guy's rights was protected under the Fourth Amendment. So therefore, in that case, you may argue that whatever you found there, that evidence can possibly be banned from being used against him in the court of law. That's how that works. Go back and read the CATS test. And look at this in terms of what you're doing. You're briefing these cases, and especially read Terry v. Ohio. That'll be one that you can argue. And I don't want to go too deep into it. We'll talk about it later. We're talking about these searches and seizures. That's what you need to know in a nutshell, so we don't have to come to class and you can just focus on your exams. Listen to this twice if you need to. Go back and look into the Zoom that I'm going to post before you take your exam. I believe in you. You can do this. If you have not been doing well, you have time to catch up, but you don't have too long. After these midterms, I need you to be on track. If you want to do well in this class, you can do it. I believe in you. And this is just another lesson on your rights under the criminal procedure and evidence under Dr. Miley for searches and seizures. Remember to brief a case. You need those facts really quick, 3 or 4 sentences on them. You need that issue. Why are you here? What's the issue in the case? What are they arguing about? The rule. What is that law they were talking about there? One liner. A is the analysis. That's everything. Your gumbo that we talked about, right? C is the conclusion. What did the court have to say about it? So what I'm doing in that analysis, right? I'm applying, but I don't want you to call it application. You call it analysis. I'm applying. I sit here and I say, okay, this is what the court ruled. This is what I think about what the court ruled. This is why I think what I think about what the court ruled. And this is what I would have done. And these are my beliefs about that. In order to have my beliefs, I have to have evidence. That information I'm going to use to back up what I'm talking about. It's not enough for me to say, I don't like what they did. That won't get you the grade, and that's not going to help you in life. Why don't you like it? What did the court say? What evidence? Do you have precedents from similar cases? Has something personally happened to you? Have you researched on this topic? You use all of that to come up with your conclusion. Thank you. This has been a great day. Do well.